Did you receive that and review that with your attorney and understand it?
Yes, Your Honor.
Are you the same Ruben Rendon Jr. who's placed on community supervision in 2024 CR 011707 for the offense of robbery on February 3rd, 2025 for a term of 8 years? Is that you?
Yes, Your Honor.
All right, state.
We're going to proceed on the first two on the original, Your Honor. The only one on the second amendment. In Bexar County, Texas, the defendant, Ruben Rendon Jr., did then and there fail to report to the supervision officer as directed for the months of June and July 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And on or about the 12th day of June 2025 in Bexar County, Texas, the defendant, Ruben Rendon Jr., did then and there fail to comply with the rules and regulations of felony drug court, in that the defendant failed to appear in court in violation of condition number 41.
How do you plead to that?
Your Honor.
And lastly, in violation of condition number 1 on the second amended, on or about the 31st day of August 2025 in Bexar County, Texas, the defendant, Ruben Rendon Jr., committed the offense of failed to ID in violation of condition number 1.
How do you plead to that? True or not true?
We'll waive the rest.
Any objection to the waivers?
No, Your Honor.
The judge reminds him he was placed on community supervision for robbery just earlier this year. Now, he's back for violations, missing meetings, skipping court, and even a failure to ID charge. The repetition of true hits hard. Each admission feels like another door closing. There's no lawyerly argument, no denial, just acceptance. See, at what point does a second chance stop being a chance at all?
Did you understand by pleading true to violations 4, 41, and 1, the court could find it true, grant the motion, and sentence you up to 8 years up to 10 years in the prison? Knowing that, do you still wish to plead true to violation of conditions 4, 41, and 1? Court will find 4, 41, and 1 true. Is there a proposed agreement?
There is not, Your Honor. The state is recommending revocation and 6 years TDC.
All right, defense, what are you requesting?
We're requesting actually the recommendation from the probation office is that he gets additional help for drug issues that he has. We're asking the court to follow that recommendation. We're asking for safety. He understands that he would have to leave. He's willing to do so. He also is telling the court that he has a problem. He did complete the lifetime inpatient. However, once he was released, he had some issues after that.
All right, is there any?
The prosecutor doesn't hold back. They want revocation and 6 years in prison. To them, it's simple. He broke the deal, he faces the time. But his defense steps up, asking for mercy, pointing to his drug addiction and efforts in treatment. They say he needs help, not punishment. It's the classic courtroom crossroads, rehabilitation versus consequence. Should addiction excuse repeated violations, or does accountability come first?
Anything you wish to say?
Your Honor.
Can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Ruben Rendon Jr.
All right, what do you wish to say?
Your Honor, I did learn a lot from the good people at Lifetime Recovery. And the one thing I didn't follow through really messed me up when I stayed with her. I should have changed the people, places, and things like Darnell taught me, and I did not follow through. And I know that if I'm given this chance, Your Honor, to do this again, I know I've got to do this right. I have grandkids, and I definitely don't want to be put away for the long time that they're trying to put me in. But I definitely know I can get this right, and I need to get this right. Your Honor, I'd like to please have this chance.
All right, so Mr. Rendon, felony drug court is a very intensive program, and they're there to help you. And if you don't show up for them.
Ruben raises his hand, swears in, and begins to speak. Nervous, emotional, honest. He admits that recovery taught him valuable lessons, but he failed to follow through. He talks about his grandkids, about wanting to change, about not wanting to be put away for a long time. It's the kind of raw moment that reminds us these cases aren't just numbers. They're lives on the line. Do you believe people like Ruben deserve one more chance, or is it too late when the pattern repeats?
Then nobody can help you. And it appears that you stopped showing up. And I know that felony drug court will spend time trying to work with you. Even if you were to abscond, they will send people out. I've seen probation officers try to go out and find people. The police try to go out and find people. But when you don't show up, there's nothing that we can do. I'm going to grant the motion, revoke you, give you credit for any time served. I'm going to sentence you to 5 years in the prison, give you credit for any time served for any successful inpatient treatment. And I'm going to request the therapeutic community for you. Therapeutic community doesn't increase the time that you're in custody. However, it does help you with any addictions you may have. Do you understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is
The judge listens patiently but stays firm. She explains that felony drug court tries everything: calls, visits, tracking. But when a person stops showing up, there's nothing left to do. Her tone is compassionate but resolute. Then comes the final line: I'm going to grant the motion, revoke you, and sentence you to 5 years in prison. It's not said in anger, it's said in disappointment. Is that justice or just inevitability?
as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. When you're released from prison, if you cannot find a sober living home, or if you can't find somebody to help you with your drug addictions, if I'm still here, you come back here. I'll pick up the phone, call a place to help you, okay? All right, thank you.
Even as she sentences him, the judge adds something few expect. She says that when he's released, if he can't find a sober home or help, he can come back to her courtroom and she'll personally call a place for him. That's rare compassion, a glimmer of hope amid a harsh system. What do you think? Should judges show more humanity like this?
Who else is ready?
Prashant, are you ready? Yes.
All right, State, are you ready?
Yes.
All right, the court is calling 2025 CR 0048887 State versus Juan Alberto Martinez. Could I have parties announce?
Megan Gallery for the state.
Robert Featherston representing Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, first things first, defense, you requested a PR bond for your client and the defendant was to be interviewed. Is that correct?
That is correct, Your Honor.
All right, the court is in receipt of the interview report. State, have you had a chance to review it?
No, Your Honor.
All right, if you'll pass that to this one. All right, thank you. All right, defense, is your motion?
Thank you, Your Honor, by way of proper. Judge, Mr. Martinez has no bank accounts, no personal property.
I'm sorry, just a moment. Excuse me. If y'all could wait, we're on the record. Counsel, you may continue.
Thank you, Your Honor. No personal property of note, no vehicle, no boats, no real property. He relies on his mom down in Laredo. His home is in Laredo. Judge, the court does need to know that there was a violation report on May the 13th for failure to take a drug test while he was down in Laredo. Judge, the testing agency down there in Laredo demanded $75 from him that he just did not have. And was unable to get his testing completed. Judge Castro went ahead and increased his bond to $25,000, and he's been in custody ever since and being picked up for that bond increase. He was originally given a PR bond back on February the 26th of this year by Judge Navra. Very respectfully requesting that, the court consider, putting him again on a PR bond and allowing him to reside in Laredo.
The focus shifts. Another man takes the hot seat, Juan Alberto Martinez. His lawyer requests a PR bond, basically release without payment, arguing he has no money, no car, and lives with his mother in Laredo. But the prosecution strikes back, pointing to his missed drug test, new charges, and flight risk. It becomes a battle between hardship and responsibility. Would you trust someone with a history of skipping tests to show up again?
Tendency of this case, any possibility of giving, Mr. Martinez a break on any drug testing charges, would be, appreciated if this honorable court were able to do so. And I thank the court for its time.
All right, state.
Yes, Judge, so I would just ask you to take judicial notice of the court file, but I just want the record to be clear. The defendant was granted a PR bond on February 26th of 2025 in the amount of $10,000. And he bonded out, and then he received the violation report on May 13th of 2025 for non-compliance, and that was for failing to complete the random drug vaccine. And then after reviewing, I guess, defense's exhibit of the PR interview, it would appear that the defendant proceeded to pick up 2 new cases in Laredo, Texas while he was on bond. And so given those facts, I think he's a flight risk based on what I read. He has sufficient ties to Laredo, and it appears like he has family that lives down there. And I guess if he was living with his family, that family, when he picked up those new cases, I don't think that that's a good environment for him to return back to. Additionally, give me just, I think the record is clear that, I mean, the PR bond was not sufficient for him to appear in court because he was previously been granted one and did not appear after that violation report. That's why the warrant went out. And I don't think he was picked up again until he was booked in Laredo and then extradited back here. So we believe that the bond is set and is sufficient, and therefore I would also offer State's Exhibit B1 for purposes of this hearing.
All right, have you?
No objection for purposes of this hearing.
All right, then states B1 is admitted for purposes of this hearing only. Just give me a moment to review.
Thank you, Your Honor.
All right, the court has reviewed states exhibits B1, and the court has reviewed the PR bond interview with pretrial services. Any response to the state's argument?
If the court will allow.
Yes.
Judge, there really is no evidence in front of this court with respect to flight risk unless you consider Laredo itself to be a.
The defense insists there's no evidence Martinez would run. They point out he's poor, not dangerous. But the prosecution counters with hard facts. He missed court, picked up new cases, and was extradited back after disappearing. The tension builds. The defense argues desperation. The state argues discipline. Who's right? The lawyer asking for mercy or the state demanding caution?
Like this. But there's no testimony that he had connections across the border. There's no testimony that Spanish is his principal language. Really the only issue with respect to flight risk would be to say that his principal residence is Laredo.
Mm-hmm.
He has 2 new allegations against him, but they're allegations down in Laredo. If the court grants a PR bond here, he has to go back to Laredo to answer those new allegations. So that he'll be transferred by the state back down to Laredo to take care of those particular issues.
All
Judge, I have nothing further.
All right, thank you. All right, after reviewing state's exhibits in the pretrial services interview for a PR bond, the motion for, or the request for a PR bond will be denied.
Okay, thank you, Your Honor.
All right. And then are you all ready to take up this other motion?
Judge, I need more time to get with my
Okay.
office to see if we have the resources to do what's outlined in the CCP, or if we need to do the in-court. So if I could have a little bit more time on that.
And so counsel, the court understands that whatever the state's resources are, there or lack thereof, doesn't play a role in the court's decision on what should be granted. Like if there's not funding for something, I'm going to follow the law whether there's funding or not. So
Thank you, Your Honor. With respect, well, two things. With respect to the
After reviewing both sides, the judge delivers her ruling. The motion for a PR bond will be denied. A clean, sharp statement. No dramatic pause, no lengthy explanation, just justice served efficiently and coldly. Then, as the courtroom prepares for the next case, a new tension rises. An identity hearing might change everything for Martinez. Could this be his way out, or just another delay?
bond hearing today, would the court reduce his bond from 25 to a different figure of,
no.
you want to keep it at 25? Okay.
Yes.
With respect to the identity hearing, Judge, we would like to have the identity hearing as quickly as possible, pursuant to the court's calendar. And also in my motion, I requested a protective order that the detective that's the subject of the identity hearing not be shown any booking photographs of Mr. Martinez until after either an in-court lineup is done or the Code of Criminal Procedure 7 photo lineup.
All right, well, let's do this. Let's have you, if you'll confer with the state on a time to have this hearing. And then if you all approach the coordinator and let me know what time you all have agreed upon, and then we will set it and we'll have it.
You're most kind. Thank you, Your Honor.
All right, thank you.
Just one question. Do you want that hearing like around the jury trial, like we're doing it on Monday and speaking to jury Tuesday?
We could do it that way, because I know we haven't set a jury trial in this case. I mean, a jury trial date.
That's correct, Judge. We
Because their
have,
final discovery is October 20th.
that's correct, Judge. And the issue is now, he can't make his bond.
Okay.
So he remains in custody. However, if we get an identity hearing done as quickly as possible, it may turn out that the state is going to dismiss this case based upon the results of the identity hearing. Conversely, if the identity hearing does not go this way, it may end up in a complete.
Well, let's do this. With regards to the identity hearing, it will be no later than October 20th.
Thank you.
But if you all are able to come to an agreement to have it sooner, then we'll have it sooner. But at the latest, October 20th, because you're already set here in the court on October 20th for discovery.
Does the court have a preference as to whether it would be a in-court live lineup or whether the photographic procedure would
Oh,
be
I'll
sufficient?
let you confer with the state, because they're saying there may be some resource issue. So maybe if you confer with the state, maybe y'all come to an agreement that it's a photo lineup if I grant your motion, or y'all may say in person. I don't know if they can find people in person. It's sort of, it reminds me of the episode of Brooklyn, what is it, Brooklyn Nine-Nine?
Oh, yeah.
Where they do the lineup. And when they do the lineup, the lady says, I just remember them singing that way. And so he said, everybody sings a note. So I don't know if they'll be able to find people to come in for a lineup. They may only be able to do it by photo,
Well,
unless we have some actors. I don't know.
Judge, I understand that. Years ago, in Travis County, we had to do a pickup jury where the bailiffs went out in the hall and just found people, pulled them in, and then they became jury panel.
Oh, wow.
So, we have that option here if necessary.
All right, well, just let me know. And if you all get together and give me an idea of when you all want to do that, and as I said, Mr. Martinez, the latest will be October 20th.
Thank you, Your Honor.
As the lawyers debate logistics, the judge lightens the moment, joking about Brooklyn Nine-Nine and old courtroom stories. It's a brief but human break from the legal grind. Even in heavy cases, laughter finds its way in. But the message is clear. The system will move forward, and both men, Rendon and Martinez, must face what comes next. Do moments of humor help ease courtroom pressure, or do they feel out of place in such serious matters? Professional overview both cases in this hearing reveal the fine line between justice and mercy. Ruben Rendon Jr., once offered a path to recovery, fell back into old habits, and the court could only respond with consequence. Yet even in judgment, his judge left the door open for redemption. Juan Martinez, facing bond denial, met the full weight of accountability, a reminder that the court's patience has limits. Together, their stories show how justice isn't just about punishment, it's about choice, change, and timing. Call to action. If these courtroom moments moved you, hit like. Drop your thoughts in the comments and subscribe for more real-life courtroom stories where every verdict reveals a deeper human truth. Oh, would you have ruled the same way as this judge or shown more mercy?